There's more for the SEC to lose than Ripple to lose where we are in the case, which is why now the tables have turned, and I think it's just better for them to settle.
This content is brought to you by Uphold, which is a great crypto exchange that I've been using for years. In fact, I've been using them since 2018. They have 10 plus million users, 250 plus cryptocurrencies, and they're available in 150 countries. You can also trade precious metals and 37 fiat currencies on this platform, and you can instantly swap between crypto and precious metals and these fiat currencies. So Uphold is a unique platform. If you'd like to learn more about Uphold, please visit the link in the description. Welcome back to the Thinking Crypto podcast, your home for cryptocurrency news and interviews. With me today is attorney Fred Rispoli, who is the founder of HODL Law. Fred, great to have you on.
Tony, the SEC has lost again, and it feels good.
Yeah, absolutely. The losses keep racking up for Gary Gensler and the SEC. So, Fred, for those who may not have heard the news yet, I don't know how that's possible, but give us the details. What happened yesterday?
Very quickly, we just got a filing come through on the electronic filing system in the Ripple SEC case that says the SEC is voluntarily dismissing with prejudice all claims filed against Brad Garlinghouse and Chris Larsen. So really, this does not affect Ripple, the company, at all. It only goes to Brad and Chris's claims, which are the only claims that were left to go to trial. There's some tangential aspects Ripple was involved in that we'll talk about, but from a procedural standpoint, getting the two individuals out, and there was no settlements, there was no money paid by any of those two, no claims that there was any wrongdoing at all. I mean, just an absolute tail between the legs capitulation by the SEC. And I haven't looked at it yet, but I saw it come through this morning. They didn't even It's so rare for them to just lose and give up like this that they didn't even file it right. And they have to refile their give up notice to the court because they did some procedural error.
Wow. Fred, it seems like a little bit of scrambling, a little bit of let's get this thing off the table because this is going to open up a can of worms for us. Why, and take us behind the scenes, why would the SEC not want to continue this with Brad and Chris?
Well, they just really had no case against them from the get-go. It goes all to your state of mind in this type of remember, it's not a criminal case. It was a civil matter, but this type of civil liability they were trying to pin on Chris and Brad required recklessness, which you have to prove, you knew about the risk or you should have known because it was so obvious and you just tossed it to the wind. And there's just no way that was going to happen, because the SEC knew about Ripple and what they were doing for years and years. Brad and Chris spoke to the SEC. I mean, this would all come out in testimony. And there was some sadness that Brad could not get certain notes that were taken by the SEC of his time when he met there, but they were, it was unfortunate, but they were unnecessary, because think of Brad on the trial. I mean, he could say whatever, he should say whatever's truthful, but, with nothing to prove exactly what happened between, three people in a room, Brad would just have gone off. I asked him point blank, is this okay? Yeah, he could even say, was what I'm doing reckless? And, and Jay told me no, he didn't even say anything. In fact, he kind of was looking at me with these deep eyes, kind of indicating I should keep doing it.
Right.
It's just, that's what trial is. You get to throw out all those crazy things. Well, I shouldn't go that far, but there's a lot of unpredictability in trial. And, that Bill Hinman was going to go on. You're going to get the SEC saying they were trading XRP and Ethereum and making their own money on the side for, so many years. It would have been a disaster. The only reason that was filed, it's prosecutor 101 in criminal cases, civil cases, any government agency. What individuals can we sue to squeeze, to make uncomfortable so they'll dance and say what we want them to say? And, normally and sadly, that works. And it didn't work here. And it didn't work in spectacular fashion.
Right. And Ripple Stewart Alderati, he's the chief legal officer, said this is the third loss for the SEC in this case. Obviously, going back to the July 13th ruling, where XRP was declared intrinsically not a security, sales on exchanges not a security. Then earlier this month, Judge Torres denied the interlocutory appeal attempt by the SEC. Now, obviously, the SEC threw out this case or this part of the case. What are the implications of all these losses for the future of this lawsuit and a settlement potentially being in the works?
Sure. I will say I do disagree with Stewart just a little bit in that I don't think he's counting right. It's more than three losses. I get if he's starting from the July 13th, yes, Stu, it's 3-0. But I mean, if you really go into it, it's maybe like 5-6-0. I mean, remember, they've stacked up a lot of losses in the last 3 years. But that aside, what I think matters is what's the mindset of the SEC. So now it's obvious. I mean, it was obvious to everyone, but finally to the SEC that they weren't going anywhere with that individual case. They blew up in their face, utter fail, especially by the lead attorney, Jorge Tenrero. And okay, we get it. They completely capitulated. Now, is it because they only are like, all right, that was a terrible idea, but now we're really going to focus hard on hammering Ripple in the damages phase and then getting that wrapped up and appealing to win everything we lost before Judge Torres? And so that's a bummer if that's their mindset. And, we'll still be taking this thing a really long, or Ripple will be going the distance with this. Again, we're not going to get an appellate result until September of 2025. I would have said 26 if we were doing the trial. September of 25, that we're not doing the trial. So it's out there, but I mean, think about everything that could happen between now and then.
Sure.
What I think is more likely, maybe not, 80-20. I mean, I'm probably closer to a 60-40, is that the SEC has come to the understanding that their credibility with the court is shot. Again, in the interlocutory appeal decision, this is like the fourth or fifth time either Judge Netburn or Judge Torres has made a comment like, and the SEC's next argument, which is totally contradictory to his first, right. Or, in the SEC, which just switched up its argument from what it argued before. I mean, that is the judge telling you, that's the most polite way, or that's the way a judge tells you, like, I don't believe anything you're saying anymore. So please stop doing that. And so if they've realized their credibility is gone, then really we're in the very last stages of this. And I believe there's settlement numbers going back and forth. I think the SEC is trying to feel Ripple out as to what they're going to pay or not pay. And so the dance now, I think, is Ripple needs to figure out the best way to telegraph they're willing to pay a lot of money. I think what they're going to try and do is they've got to do a delicate dance of trying to figure out how to convey we're actually willing to pay more than we probably should if you cut this off and we settle this now totally, finally, and forever, versus the hardline approach, which is, you've got something on paper right now, tentatively for 770 million-ish plus, but we are going to fight that tooth and nail. We're going to get that reduced. That's going to get lowered. You're going to get a fraction of that. So, we'll be lucky to, you'll be lucky to get, whatever. So why don't you just take 50 million right now and let's call it a day. Sure. It's which track do they want to go down? And I can see the merits to both tracks. And, there's settlement negotiations, I think, that are happening. And I think, we're going to get this done sooner rather than later, but we'll just have to see.
Sure. Hard question. Do you think likelihood of it wrapping up this year versus next year?
I think it'll be easier for me to predict after we see what happens in early November with the brief, what they filed. Did they agree to a briefing schedule? What is it? Do they argue over the briefing schedule? I mean, if you can't even agree to a briefing schedule, you're still probably fighting each other pretty hard. And so we'll kind of see early November what that looks like. Maybe we'll be able to see the tea leaves a little bit better. I think, I mean, there's no real reason to delay this anymore because the SEC knows without the trial, really Ripple's not burning the amount of money on legal fees that they would be burning for a trial. So it's not like the SEC is hurting them on that front as much anymore.
Sure.
So everything that the SEC has as leverage is gone. The only thing that they can have is their appeal and say and threaten how much they're going to get that overturned and win. But people got to remember that Ripple is in the exact same position on that appeal, which is, hey, SEC, an appellate court is going to look a lot harder at our no written contract, no contract at all argument, and you're going to lose everything. So in 1998, there was a great hip hop album, Sittin' Fat Down South. And what I'm saying right now with the SEC is they're sitting fat on 770 million right now that they could completely lose and could evaporate into nothing if Ripple, wins on appeal. So there's more for the SEC to lose than Ripple to lose where we are in the case, which is why now the tables have turned, and I think it's just better for them to settle. One aspect of the Garlinghouse Larsen thing that it just is a different perspective than what I've been seeing on social media. So when you get the offer from the SEC to dismiss with prejudice a full, complete loss, I agree with what I've heard a lot out there, which is that it's a no-brainer to accept something like that, to completely get your client off, dismiss with prejudice. And I'd agree that that's what you do in 90% of the situations, but I don't think that was the right play here, which makes me wonder if it was a decision that I wouldn't have advised, or there's something a little more going on, which leans me why I think there's going to be a settlement, which is because it is true that it's extremely anxiety inducing to be a party in a lawsuit. I can say that experiencing it exactly, especially as a lawyer who has clients, usually personal injury clients that are, desperately injured, and this giant corporation is trying to crush them, not pay them what they need to live a somewhat okay life, and to threaten like legal fees against them. But that's not the case here. Yes, Brad and Chris may have some anxiety, but there's no criminal charge, so there's no threat of incarceration. One of these people is a centimillionaire and the other one is a billionaire, okay? They have all the money to pay any legal fees they have to. Money is no object. But even more importantly than that, they are executives in a multi-billion-dollar company that have indemnity agreements with the company, where I would say with a 99% likelihood, Ripple is paying the legal fees for Brad and Chris. They can't make any decisions in their lawsuit. It's a separate lawsuit, but they're paying the legal fees. So there's just not that anxiety, especially when it was so obvious that they were going to get crushed in court. There's always a chance you can lose. You can't say 100%, but it's kind of like, is there a chance that SBF isn't going to lose in this case? I mean, okay, I will eat my words if they come back and say, not guilty, but I'll be stunned. I mean, there are cases where it's almost a sure thing. You can't say a sure thing, but you can say pretty much a sure thing. So why would they agree to a dismissal without more concessions from the SEC, like pay our attorney fees or pay some sort of penalty or make a statement? I mean, you can ask anything you want, not that you're going to get it, but just the straight up dismissal, I just think they had more leverage to get more from them than just that straight up dismissal. And remember, this dismissal is not even approved yet. Under the rules, they have to file this with the court, and the court has to approve it. Now, I think the court's going to sign off on it, no questions asked, but Brad and Chris could have made the SEC, they could have said, we're not going to agree to dismiss this. they could have made the SEC file a request to dismiss over their objection, begging the court to dismiss the case that they filed purportedly in good faith, and would have at least been another humiliating defeat, because the judge probably would have granted it, but would have written an opinion saying the SEC needs to think about these things. Why would they bother filing this if they thought they had a chance? I mean, there was a much bigger avenue for humiliation than just agreeing to this. And so why did Brad and Chris just take the voluntary dismissal? Well, they either took the easy route, as everybody kind of is mainly saying, or there's an agreement already, and maybe not publicly disclosed, maybe not a written agreement, that, each side could potentially back out of, because it's kind of like in the background, in the ether, so to speak. But there could be an agreement of the minds that, we won't make this more humiliating for you, but we've got an actual settlement. We're going to hammer out some of the numbers. It's in this range. We'll, maybe we'll even file a few motions, but we're going to get it done before end of year. And it's, it's over. So, and I just lean towards that route, because they just, they really had the SEC over the barrel here. So I don't know. I understand taking it as is on the face, but I think there's more they could have done, and maybe they did do. So I'm excited to see if my intuition is right on that one.
That's great insight, Fred. I love how you mentioned that the tables have turned, and Ripple seems to be in the driver's seat here. And in addition, to Gary Gensler and the SEC losing in the court of law, they're also losing in the court of the public opinion, right? Where this thing is so high profile, it's making the media headlines. There's members of Congress talking about it. There's members of Congress putting out bills to restructure the SEC, tweeting "fire Gary Gensler." Not to mention, in conjunction, Coinbase is fighting back. Binance is fighting back. The SEC has lost to Grayscale. When you add all these things up, the SEC is not in a good spot here. And then just this week, Mark Cuban and Elon Musk decide they're going to team up to sue the SEC. So things are not going in their direction.
They're not. And, it was great to see what Mark and Elon decided to do. And, I do, obviously I only know Elon Musk from following what he does publicly, don't know the guy at all. One thing that disappoints me, I'm sure someone could find something that disappoints, someone else and everything, but as much as he's hard on the SEC, I still think there's just a level of fear that prevents him from doing a lot of things. And I get it, when you have multi-billion-dollar companies that are run, totally regulated by the SEC, my law firm isn't. So, I can be a little more harsh on my criticisms of the SEC, but it's great that he's doing something, him and Mark, but there's just so much more that he could easily do to just level those guys, which would be to start accepting a multitude of digital assets as payment on Twitter. That would just completely torpedo the SEC. Just a gut punch to no end, and open up a whole nother front of litigation, especially if he were to start accepting all the coins that, SEC has gone after, really rubbing it in their face. So I'm glad he's doing that. A lot of people are starting to fight back. I wish there was more. There could easily be more. Again, my firm, a bunch of other firms, if the right people were like, why don't we file these, 27 lawsuits? We could go lawfare the other way, and hopefully it happens, but we're inching along when we could be, moving by miles.
For sure. What were your thoughts on the Grayscale ruling? Those three judges came out pretty strong, using the wording arbitrary, capricious about the SEC not approving the Grayscale Bitcoin spot ETF. What were your thoughts on that ruling? And do you anticipate an approval of a Bitcoin spot ETF very soon?
So that was another whooping that was handed down to the SEC, and this time by a circuit court of appeals. SEC didn't appeal. Gary Gensler tried his best to make it look not so bad when he was glossing over it, but they're not appealing. The SEC could come up with an entirely new, arbitrary, and capricious way to deny all these ETFs. That's a possibility. I think it's very unlikely. I mean, on the one hand, there's absolutely no accountability for the SEC. So that's why, if they decided to come up with some ridiculous reason to deny the next round, that's why I can't put it past them.
Sure.
But I mean, it would just take it to such an extreme level of ridiculous that I don't even think Gary Gensler is willing to go there. And the funny thing is that many people might not know that Grayscale has filed formal oppositions to the approval of all the other ETFs for Bitcoin.
Really?
Because, and all those oppositions say it's not fair for you to approve any of these because we've started at the very beginning and we've been waiting and we filed the lawsuit. So, and that makes sense. I'm not begrudging them over that, but it's just, interesting that they've actually opposed those. So I think they'll get approved. I think you're going to have a handful all approved at the same time.
Mm.
So it just seems less like favoritism. I think all the big boys that we know of, like the BlackRock, the Fidelities will get included along with Grayscale. And it'll be great. And I think I would tell everybody, look at what happened with gold when the gold ETF was first approved. If you want kind of it might not be the exact same way, play out the same way, but, if you want some indication as what's going to happen. So they're coming, when are they going to come? I don't know. They can always, the deadlines are deadlines, but they can always say, hey, why don't you withdraw and refile, and we're going to approve this within the next 40 days or whatnot. So the timing is still a little unclear, but we're in the last leg. This one we are in the ninth inning.
Yeah. And, going back to the court of public opinion, if you got Larry Fink going on TV saying the time is right, we're ready for a Bitcoin spot ETF, and you're Gary Gensler, it's not going to work out well for you, especially when, these institutions of that caliber that make campaign donations and much more, right? I think he's on the losing side again, right? And as you mentioned in the recent interview, he tried to gloss over some things. He did make some statements that, the staff is looking at the disclosures and yada yada. So I just feel the wind has been taken out of his sails. It's no longer, well, no, we can't allow these things, and this is happening, and he's very timid, it seems like.
Yeah, and people might be shocked for me to say this, but I want to stress that Gary Gensler is not anti-crypto in any way, shape, or form. If his masters told him, after we're done recording this, that like crypto's the greatest thing, we're going to make a ton of money, now be for it. Later today, he would release a video saying how great crypto is. It's the biggest, asset to invest in, wonderful for, investor protections. So it's not like he cares about crypto one way or the other. He's just doing what, his people are telling him to do. So
Right.
again, if enough people, like we saw Larry Fink come on and, start telling him, now do the other thing, he'll do other thing, and he'll do it gladly and willingly.
Yeah, you're absolutely right. And his history proves that. The man was promoting Algorand, teaching crypto and blockchain at MIT, tried to go apply for a job at Binance. These things have come out. So he knows the technology, he knows the benefits. But to your point, he is in that seat, and that seat is beholden to whoever the masters are telling him. And maybe it's Elizabeth Warren and some of these TradFi guys.
Yeah, exactly.
So the Coinbase case. So Coinbase, we know they are fighting back. They're suing the SEC, asking for clarity. The SEC is also suing them. There hasn't been too much news lately around that. Any updates that you can share? Anything you've seen?
Yeah, a few updates, nothing major. I'm not a fan of Coinbase, although I am a limited fan of them beating the SEC. What's going on right now is some pleadings, a motion for judgment on the pleadings filed by Coinbase, very similar to a motion to dismiss, which is even if you believe everything that the SEC alleged against us, Your Honor, they can't win because legally you can't file a claim like this.
Hmm.
And so, they're basically saying these things individually aren't securities. If they're sold on an exchange, they're not securities. And so that's being briefed right now. The opposition was just filed by the SEC. The reply for Coinbase will be filed on October 24th. And I don't think we'll get a ruling until probably January of 24. I mean, depending on how on top the court is on this, I would be very surprised, but maybe by the end of this year, we'll get a ruling. There are a lot of amicus briefs that have been filed in this thing. And, believe it or not, SEC has gotten a lot on their side saying, they've got the right to do this, to be innovative in how they enforce the securities laws. They are all, by and large, if people remember with Ripple, there were some randos that supported the SEC. Similar briefs here, like random law professors, random institutes of finance, it just seems like, again, it's the SEC trying to pull in as many favors as they can in the face of other amici opposition. So it's a big briefing, but it's not even done. It's not even fully concluded, and the court's going to take, a couple of months, I would think, to make a ruling. I think the Coinbase is probably going to lose that. It's just hard to win at that early stage against the government, and so there's a bigger chance than normal, but I would indicate it'll go to the next round where at least there's some discovery, and then Coinbase probably wins something on a summary judgment. But we're a year away from that if that happens.
Sure. Do you feel Coinbase can use some of the case law in the Ripple case, especially the exchange aspect of a coin being sold on an exchange, not necessarily a security? I know Judge Torres said in her recent denial of the interlocutory appeal that, look, this was specific to XRP, but I can imagine that some of this could be used by Coinbase, right?
Yeah, Coinbase will use it. I think they probably already have. At least I think they used the July 13th opinion. I don't know if they'll probably file the interlocutory denial opinion in their reply. And there's actually, Coinbase was sued in a class action over very similar allegations the SEC made in New York a year or two ago. I want to say it was the Underwood case. And the court actually dismissed that case on the pleading, saying, you had these third parties trading, they weren't securities, or it's been a while since I reviewed it, but
Yeah.
my recollection is that civil case class action was very similar to what the SEC alleged. So I think I think if they may have even used that in their briefings already, I'm not sure, but they won on a very similar issue already. So
Mm.
they'll use whatever they can. The SEC will say no, that's related to XRP, Ripple, factually distinct, and then the judge is going to just make her decision.
Mm. Now, I want to wrap it up with the suits that you had at your firm, HODL Law, one against Coinbase regarding the Songbird issue and distribution, and of course, Ethereum, clarity around that. Any updates there that you can share?
Yeah, I haven't put out a tweet on this yet, or an X. Sorry, I take that back. This just happened last week. We in the Coinbase Songbird Flare, we actually got a really rough ruling. We were fighting a motion to compel arbitration from Coinbase. That's nothing to do with the merits. It's just saying, hey, Fred, your firm and your clients cannot sue us in court. We buried this arbitration provision in the terms of service, and you have to go into this forum that, by and large, we generally control and can dictate, the outcomes. And so it's definitely disappointing. It was the likely scenario because a lot of courts are granting these. There were some in that district that have denied them, and there's a Coinbase arbitration on appeal in the Ninth Circuit right now that could change everything for the better. But we got ours forced to arbitration. There's a lot of ways and strategy that we kind of need to think about going forward to try and help everybody get their songbird and flare. Things I just can't get into right now. But we're thinking about what the next step is. And, if anybody ever has any questions and you're on the class list, just shoot an email to our firm, contact@hodllaw.org. And we'll try and we'll update you where possible. And, we'll try and put out everything on social. The other thing that's going on is our firm, we were suing the SEC to get a declaration that Ethereum and its network is not a security. We were dismissed in that case on lack of standing. The district court said, hey, we don't think you're going to suffer enough harm by not knowing. And the SEC came out in that case and said, in court, we haven't made a decision. Everything that HODL Law said about the Ethereum speech, the emails, all of that means nothing. We haven't made a decision. So that is their official position in court, wow. If anybody is curious. And we just filed our notice of appeal. We're going to have briefing in the Ninth Circuit starting in late November. And, we're just going to say, and it's not just the SEC, it kind of is more of a fundamental thing of, can a citizen, in this case, a company, sue a government agency saying, you're not telling us what you think is right or wrong. This could severely impact, our business, our livelihood, even our freedom if it's, a jailable offense. We want to be able to demand an answer rather than wait for you for 8, 9, 10 years to make a decision. And I think that could framed that way, I think that could catch the eye of some of the appellate court judges up there. And so, hopefully we'll be allowed, because really, we just want a declaration saying, hey, Ethereum's not a security. Neither is the network. Let us go about our business on this, or tell us it is, and then we can figure out something after that.
Fred, a question for you is, and I don't know if this makes sense. Could you introduce what, like, Patrick McHenry and the other members of Congress and the House Financial Committee were asking Gary Gensler in public at a hearing, is Ethereum a security? And he can't answer it. Is that like evidence that you can also use?
Yeah, so we had some of that evidence in our pleadings when we lost, and I just don't think, these are big legal questions and against very important agencies, and some judges just don't want to get involved and they don't want to deal with it. And if they can get a case off of their docket because they're so overloaded, they will. So, there was just not a lot of meat on the bone of the opinion, granting the motion to dismiss. And, because it was before the McHenry hearing, it was another hearing a long time ago where Gary Gensler wouldn't answer that question. But all that other public information, will be included in our brief, and the fact that, in that Coinbase case, we had a senator file something saying, the SEC doesn't have the authority to do this. So, we're going to put it all in there. So, the courts know what's going on, not just in our case, but, the strategy on a nationwide basis with the SEC. And, we'll just see where it goes.
For sure. Well, Fred, certainly appreciate you, man, and the fight you're doing there with your firm on behalf of many investors. And thank you for joining me and, for the insights. Always great stuff.
So, last thing, I'm going to put you on the spot here. You got to answer this question, all right?
Oh, boy.
You got to answer it on record.
Sure.
Jay Clayton, are you willing to go so far as to say he's a coward?
Oh, yeah. Jay Clayton's a coward. I would tell that to his face. Like, if I saw him walk by, you're a coward, man. Like, seriously.
One of my favorite, I made a clip of it. I mean, you say it so much, but there was one thing where you like, in Jay Clayton, he's a coward, and he's just a coward, and that's all he is he's a coward. So, well, before I move on, he's a coward, and I'd tell him he's a coward. And I just, whenever I really need a good pick-me-up, I go back and I listen to that on a loop.
Thanks, man. Yeah, one of the things I think we're seeing the cowardness play out is that he's a frequent guest on the CNBC Fast Money, whatever they have in the morning. He was actually on this morning. And as you can imagine, I'm sure Joe Kernan and these guys want to ask the question about Ripple. But I'm sure Jay is like, no questions. I want you to ask me about Bitcoin spot ETF and everything else. No crap questions about Ripple. So I think that's how the dynamic is. I could be wrong, but I think that's how it is. And he's calling the shots as to what he wants to talk about.
Yeah, I agree.
Yeah. Fred, great stuff, man. Thank you thank you for joining me, and appreciate the insights.
Hey, thanks for the invite. See you later.